right, so today we're talking about torts and strict liability. Now, we know that crimes, which we're going to talk about next week in Chapter 8, a crime is a wrong against society as a whole, correct? So that when somebody steals something or somebody robs somebody else, then that constitutes a wrong against the society as a whole. We as a society are offended when somebody breaks the laws, particularly when those laws are there to protect us. So primarily what we're talking about today comes from the common law of Great Britain and France. The word tort is not a pastry. It is a wrong against an individual. So today we're going to talk about negligence, principally, and that encompasses the whole concept of personal injury law. You may see television commercials or hear radio commercials. Have you been injured? You don't have to pay us until we collect your judgment at the end of the case. If you don't win your case, you pay us nothing. So those are primarily personal injury attorneys, and their rights to represent people derive from the common law. So they say that contingency fee law is the poor person's key to the courthouse, because you don't have to pay money to a lawyer. They'll represent you with the hopes of getting compensated at the end of the case. So that's principally what personal injury law allows us to do, that is to gain access to the court without having to hire an expensive lawyer, right? The poor person or the underserved has the right to come to court and meet their adversary. So in keeping in mind about tort law, that can encompass many things. It could be a dog bite case. It could be a personal injury case involving cars. It could be a product liability case, which we'll talk about at the end of the class when we talk about strict liability. And there could be just a garden variety slip and fall case. Somebody goes into Safeway, and if there has been notice with respect to the manager of that store that that banana has been on the ground for a long time, and they can figure that out through surveillance tapes, then in fact that management had the opportunity to clean up that banana but didn't do so. Now it's a different story when the manager or the store ownership didn't have the opportunity to clean up that problem. That means that they had no notice, and if you have no notice of a problem, then you don't have the ability to correct it. So let me sort of dissect for you the elements of negligence, and then we'll be more specific. Right now we're just going to approach negligence conceptually from sort of a high-level view. And again, if you have questions, just stop me. It's a fairly complicated area of the law, and in law school, negligence is probably 3 to 6 months of time spent just on negligence, and today we're going to boil it down to a couple hours, and we'll try to demystify the entire process for you. So for negligence, we have a duty, a breach, a causation, and damages. Now, this is an all or nothing proposition. So that if you can prove a duty that the defendant owed to the plaintiff, and a breach of that duty, and you can prove that defendant caused injury to plaintiff, but there's no injury, there's no case, right? And if you have a duty and causation and damages, but no breach, then you don't have negligence, right? So, Eric, you have to find every single one of these elements in order to have negligence. One of those is missing, we don't have a case for negligence. It might be something else, but it's not negligence. So let's talk about duty. What is a duty? Well, in this world, we sort of have implied duties to each other. If I'm your teacher, I have the duty to cover the core modules of the textbook, so at the end of the quarter or the end of the semester, I have fulfilled my obligation to you to teach you the essential elements of this course. I am duty bound to produce these lectures in such a way that you're getting something out of the experience. Now, let me ask you a Socratic question. If I'm driving my car down the freeway, if I'm on 280, it doesn't matter what freeway, Who do I owe a duty to?
Everybody around you.
Michael.
Yeah, the people that you might crash into around you.
Okay, so I have a duty to every other motorist, correct?
Yeah.
And I also have a duty to myself. Hence the seatbelt law, right? So if I'm not wearing a seatbelt and I get injured and I have a significant injury, the defendant's going to argue that I didn't mitigate my damages. So I actually put myself in harm's way by not wearing a seatbelt. So I owe a duty to myself. Seems a little bit strange, but it's true. At least under California law, I owe a duty to myself so that if I do get into a car accident, I'm protecting against greater harm. That's the concept. If I'm a police officer, I have a duty to use my firearm in a respectable way. Now, in the news lately, we've seen some abuses. I'm not going to talk about politics, but theoretically, police officers have a duty to protect every one of us, right? When they sign their oath of allegiance and when they take on the job as a law enforcement agent, they are in fact agreeing to this duty that they have. Some duties come with the job. Lawyers have a duty to zealously advocate for their clients. If I'm building a website for a client, I have a duty to program a robust website in line with my client's expectations and specifications. That's my duty. If I'm a driver in a car, like Michael pointed out, I not only owe a duty to those other motorists around me and myself, but I also owe a duty to pedestrians, right? And again, in California, pedestrians have a pretty high ability to be protected. So if they're walking in the crosswalk, this is sort of a boundary of protection. Some defendants owe a higher duty than others by virtue of their position in the world. And we call that the duty of common carriers. The duty of common carriers. Before we get to common carriers, quick story. It's about 2 o'clock in the morning, and we're in a fairly wealthy neighborhood in Hillsborough, and a burglar is attempting to enter a house through the roof, and this burglar has actually staked out this house before, and there's a lot of nice jewelry in there. There's some nice electronics, some nice Mac computers, and this burglar has been sort of looking around the neighborhood and has targeted this particular residence for this burglary. And often on the news, you hear news reporters confuse the concept of robbery with burglary, but we'll talk about that next week when we talk about crimes. But while this person is in the furtherance of his crime, when he's trying to break into this house, he falls through the roof. He falls through the roof and gets injured. And the question becomes, well, can a person who's in the middle of furthering his crime, or in the middle of conducting a crime, if you will, can that person sue for negligence? And the answer, unbelievably, is yes. Yes. That person who's in the middle of burglarizing someone else's house and becomes injured through the negligence of the owner, or whoever failed to maintain that roof properly, may be forced to pay that person damages. Doesn't sound right, right? Kind of stinks. But I told you the first night of class that justice isn't always just. It isn't always fair. So let's further analyze this concept of common carriers. The landowner, typically just somebody who owns property, may not be a common carrier. Probably isn't. Common carriers are companies like hotels, cruise ships, airplanes, trains. Typically, these are companies that are hosting other people. In other words, when I check into a hotel, my expectation to be protected by that hotel is greater than if I'm just in my house. If I'm in an airplane, I've given up my control over my journey to the pilot, the co-pilot, and the flight attendants, right? As soon as I belt myself down in that plane, I'm giving up my control. I'm not the pilot, unless I'm the pilot, of course. But if I'm not the pilot, I'm entrusting these various common carriers to protect me. And they have a higher duty. They have a duty to protect me because I'm paying them extra money to make my journey or my stay safer. Interesting case. St. Francis Hotel, San Francisco, California. You may have walked by it on Union Square. If you're doing holiday shopping or something, it's a huge hotel right on Union Square. Well, this was about 50 years ago. A person was walking by the hotel on Powell Street, I believe it was, and some crazy people were partying, and they were throwing chairs out the window. Kind of reminds me of my fraternity days back at Berkeley. And when I was walking down Bancroft, some guys at SAE were throwing some guy in a bed out the window. Oh, great. College life, how much fun is that? Anyhow, I didn't stick around to see if that person was injured because there's no bystander law. There's no duty for me to rescue somebody if I'm just walking down the street. There would have been a duty, though, if I tried to rescue that person and I made his condition worse. So it's kind of crazy. There is no bystander rule in California. And if I promise aid to somebody and I make their condition worse, now I could get sued. So these common carriers, like the St. Francis Hotel, has this higher duty. Well, back to the hotel case. Person was walking down the street. It was late at night. And some yahoos were partying. I don't know where they were. Maybe from some insurance convention from Idaho. I don't know. It doesn't matter. Anyhow, this poor soul was walking down the street, and all these chairs come down on the guy's head. And now he says he wants to sue. Well, one concept is this defendant, this hotel, is a common carrier, right, as defined here. So they have a heightened duty to protect. But remember, they also have to have some kind of notice. Did they have an opportunity to protect against this harm? Did the hotel management know that a bunch of nutcases were upstairs on the balcony throwing chairs onto the street? Well, had this happened before, if it had happened before, you might have a claim that they had a heightened duty, right? But as a common carrier, they were a target for this lawsuit because the plaintiff argued, look, you're a hotel and you have a heightened duty to your customers, but where does that argument fall flat?
He wasn't a customer.
He didn't rent a room there, right? He wasn't part of the group of people that was seeking protection under the hotel. He had no contract. He didn't rent a room. He was just walking down the street. So even though someone's a common carrier, make sure you have the right type of plaintiff. Now, had the plaintiff been staying in the hotel, walking through the hotel lobby, and the same type of action happens, you might have a better argument that because that defendant is a common carrier, they had a heightened duty to that plaintiff. All right? So these class of defendants have a higher duty. Common carriers, hotel, cruise ships, hotels, cruise ship, airplanes, trains. And other places, you might even argue that the rapid transit here in San Jose has a heightened duty to protect people. Now keep in mind though, if you are the victim of an injury through the hands of a government entity in California, you only have 6 months to sue or file a claim. You have to file a claim within 180 days. So that would also be true if you are the victim of negligence at the county hospital, right? If you're the victim of a medical malpractice claim, I think last week we talked about you go in for a right leg issue and your left leg gets operated on. Well, if that was done in a county hospital, like Valley Medical, then you'd have to file a claim within 180 days. Now, if you go to Stanford and that happens, you don't have that problem because it's a private hospital. Then you have the 2-year statute of limitations to file a claim. Now, again, I'm not giving you any legal advice. If you, God forbid, do become the victim of someone else's negligence, please seek help from an attorney, a licensed attorney, because they can tell you exactly what your rights are. So, any questions about duty? We all owe a duty to each other in one way or another. Drivers owe duties to other drivers, and if I'm a common carrier, then I owe a heightened duty. That means they have to prove that the defendant has to prove that they did everything they could to protect the plaintiff. All right? Does that make sense? All right, breach is pretty easy. Like duty and breach and damages, those are pretty easy concepts. When we get to causation, that's when things get a little bit tricky. A breach just means that somebody didn't do what they were supposed to do. It could be a breach of contract. It could be a breach of my duty as your instructor to deliver great lectures. It could be a breach of a doctor failing to give you a proper diagnosis. If I go into the hospital and the doctor says I've got kidney disease, and it turns out that I have a lumbar sprain injury because the pain is in the same region but they didn't do x-rays properly, then there may be a breach of that physician's duty, right? Without a breach, it doesn't matter how much duty that person has. Even if they have a higher duty, no breach, we don't have a case, right? So what would be an example of one driver breaching her duty to another driver? Well, how about trying to text a friend when they're supposed to be driving, or talking on their phone, or checking their navigation system, right? That could be a breach of their duty because they're supposed to drive in a very safe manner. And again, it goes back to that reasonable person standard. You might ask Mr. Silverman, well, what is that reasonable person standard? And again, it's different for every case. What would a standard driver be doing in a like situation? Right? If I'm at a red light and I know those lights change pretty quickly, would I be acting as a reasonable person if I'm trying to check my text messages at the same time? Probably not. Now again, remember, if there's a duty and a breach, but I don't cause injury, that's interesting. I might be liable for a traffic ticket, but so far there's no negligence. So breach just means I didn't do what I was supposed to be doing. Pretty easy. You'll know it if you see it. Any questions about breach? Okay. I'm going to come back to causation in a minute because that's where all the points are on your exam when you're arguing causation. Let's talk about damages. Now, last week I alluded to the fact that in a personal injury case, we want to bring that plaintiff back to their pre-injury capacity, if that's possible. We also talked about the thin-skulled plaintiff rule, which means that that person already had an injury, and our new negligence makes that case or situation worse, and we have exacerbated that injury. We will be responsible for everything we did to make that person worse. So if I had already broken my cervical spine in a pre-existing injury, and now somebody drops a box on me negligently, I can go to a doctor or get an x-ray. If I have an x-ray relative to my pre-existing injury, and now I have a film of my new injury, I can show the extent of the new damage, if any. So damages come in two different areas. And they're basically general damages, and special damages. General damages are difficult to quantify. General damages are those damages to make plaintiff whole, which represents compensation for their pain and suffering. Now, how do you put a price tag on that? Again, I told you often clients would come to me and say, hey, Mr. Soberman, what's my case worth? And they got frustrated when I told them your case is worth what a jury is willing to give you. Because every case presents with different situations. Now, if you're really interested in evaluating personal injury claims, there are books called Jury Verdicts Weekly, and you can look in those books by jurisdiction. So you can find out, what did a dog bite case involving stitches in somebody's head and emotional distress, what did that go to the jury for? How much did the jury decide that case was worth? And you can order these things. I don't know why you want to see it, unless you're an attorney or a claims adjuster, but there are precedential values for cases that you might be able to extrapolate some evaluation or some benchmark for evaluating that case. So if general damages suggest pain and suffering damages, special damages are my medical bills. Special damages are incorporated in a letter from my employer indicating how many days I missed from work and how much do I normally get paid for every day. Those are my special damages. They're special to my case, right? My medical bills are based on my injuries. My wage loss is based on my rate of pay at the time of the accident and how much time I lost from work related to my injury, right? You're not going to incorporate my sick time, my normal sick time, and my vacation time into this letter. I simply want a letter from my employer saying, Mr. Silberman was out of work for 3 weeks because of his injury, and he gets paid $5,000 a week. So now I have a letter that's worth $15,000. So when I go to the insurance carrier to try to settle my case, I'm asking for compensation for my general damages, my pain and suffering, and my special damages. That's one package. And again, to evaluate my case, I might look at other cases that I've had that are similar, or I look at jury verdicts weekly, because each county in California and each jurisdiction across the United States has different values for the same kind of case. As an example, in Brooklyn, we have very high jury values, right? In Orange County, we have very low values. It seems like the more liberal the jurisdiction, the better jury verdicts we might have. San Francisco, we have great jury verdicts. Santa Clara County, not so great. Contra Costa County, not so great. For the plaintiff. I'm arguing for the plaintiff. Okay, so that's how damages break down. Again, the damages must be clear, certain, foreseeable, and reasonable. Anybody have any questions about damages? Yes, sir.
Distress count as a damage? Emotional distress?
Emotional distress, that would be a general damage. Now, if you go to a psychiatrist, though, and you have a bill for psychiatric treatment, then that could be considered your special damages. Or if the doctor prescribed medication, you became depressed because you have a post-traumatic stress disorder, then you might have a medical bill. That would become a special. Does that make sense? So bills are technically specials. General pain and suffering, emotional distress, those are general damages. Okay? Now, we're going to spend a great deal of time talking about causation. If you're talking about causation, you want to consider something called the but-for test. The but-for test. All right? Now, the but-for test asks, but for defendant's negligence, would plaintiff had been injured? But for defendant engaging in X activity, would Y have happened? So it's a cause and effect. We call it the but-for test. But-for test. We have different kinds of causation. We have proximate cause, which is also called legal cause. We have direct causation, and we have indirect causation. And then we have something which is a little bit difficult to understand. It's called a superseding intervening factor. Superseding intervening factor. I'll try to write it on the board here. Superseding intervening factor. A superseding intervening factor is usually an act of God or some incredibly unforeseeable situation, and what that does, what the superseding intervening factor does, is it cuts off the defendant's liability. It's a defense, and we'll talk about defenses at the end of the day. But it is a solid defense if there's a superseding intervening factor that cuts off the defendant's liability. So, let's use the simple example that we used on the first night of class of a car accident, all right? So we'll have two vehicles. We'll have vehicle A and vehicle B. So here's A and here's B. Now A, the driver of A, is not paying attention. They're checking texts, and they're following too closely to B, and they rear-end B's car, and B gets an injury, gets a whiplash injury as a result. Has $10,000 worth of medical bills. Could you argue anything but A directly caused B's injury? No. A made direct contact with B's vehicle and wasn't paying attention. So far we have a duty, right? A owes a duty to B to drive safely. A breached that duty when she or he was texting their friend. And now on causation, but for A's checking his or her text, he or she would not have hit B's car. That's direct cause. Now, let's say there's another car, C. Right? And by virtue of A hitting B, B makes contact with C. The question becomes, ladies and gentlemen, did A directly cause injury to C? And the answer is no. He indirectly caused injury because there's no direct contact between A and C, right? There's an intervening factor, which is vehicle B, but it's not superseding. It's an intervening car. Does everybody get this concept? All right. Now, it's clear that A directly caused injury to B. It may not be clear that A indirectly caused injury to C. It also comes about often if one vehicle is forced out of the way due to an accident and runs into a rail and gets injured. There's no direct causation, but it's indirect causation. Does it make any difference whether A directly causes injury or indirectly? The answer is no. As long as they legally or approximately cause the injury, and we'll talk about the Paulsgraf case in a little bit of time, when we're talking about foreseeability, hopefully everybody read that case, we'll find out that legal and proximate cause will make the defendant liable for injury to plaintiff as long as the injury is foreseeable. Now, I would argue in this day and age, right, in this year of technology, in this day of advanced computer information, etc., almost everything is foreseeable, right? It might even be foreseeable that a Martian lands through our roof. I don't know. It's not that far-fetched, whereas maybe 300 years ago it was like, a Martian, what's that? But almost everything today is foreseeable, so that if somebody breaches their duty of due care, it might be foreseeable that they're going to have to pay damages to plaintiff, right? Eric, you waiting for that Martian?
I was going to ask, if
Yes.
a Martian did fall through something, who would you seek for damages?
So if a Martian fell through the roof and the roof was maintained improperly, the Martian, and no offense to the faculty members here or the administration, San Jose State, or whoever is responsible for maintaining the building such that it could have been prevented from the Martian to descend. So if he just descends through his own accord and through no negligence on behalf of San Jose State, there's no case, right? He may have assumed the risk of his own injury, which we talked about a couple weeks ago, and we'll talk about assumption of the risk too when we talk about defenses today. All right. So, what would be a superseding intervening factor, again an act of God, if lightning strikes the driver of B and that causes the incident, then that might be a superseding intervening factor. Or it could be a negligence of some other party or some strict liability. We talked about the first night of class, if A's tire blows out through no fault of A, that might in fact be a superseding intervening factor that caused the injury. And now defendant's off the hook for the injury. Now, if A improperly maintained that tire, and it was foreseeable that by driving on this almost bald tire, it would cause injury, then A is back on the hook. It's not a superseding intervening factor. It's a cause. It's a but-for cause. All right. So all you have to know about proximate cause, it's the same as legal cause, and we use the but-for test to find out if defendant's responsible. Then we talk about indirect causes, and it doesn't make any difference whether something is indirect or direct, as long as we have those other issues. The duty and the breach, the causation and damage. So I talked to you about common carriers having a heightened duty. Now, there's another level of scrutiny that I want us to delve into, and those duties surround landowners. Not tenants, but landowners. And here's the way that works out. We have something called licensees and invitees. Licensees and invitees. Now, if I want to use Perry's restroom at her restaurant, and I'm not really a customer, and it says on the door, customers only, and I walk into that restroom, and the floor is incredibly wet, and it's slippery and dangerous, and I hurt my back. The question becomes, even though there was a sign on the door that Perry's manager put up that says the bathroom's for customers only, is it foreseeable that somebody else might use that bathroom? The answer is yes. The question becomes, do I have the right to be there? If I'm a licensee or an invitee, I have a sort of special categorization. Either a licensee or an invitee has a right to be on that premises. So, if I am an invitee, I have a higher level of protection. That means I'm on Perry's premises to do business. So I might be a vendor. I might be delivering ice, or I might be delivering rice to her restaurant. And after I put my first few containers of rice down in the stock room, I decide to use the restroom. Am I a customer? No. But I'm there for a business purpose. So now Perry owes me a heightened duty of care. And what is that heightened duty of care? She has a duty to me to inspect the premises for unknown dangers. She has a duty to inspect the premises to make it safe for me. That's a very high duty, right? Now, if I'm a licensee, that means I'm just a patron, or I'm a social guest. I'm just coming by. I'm a friend of Perry's. I'm just coming by for her to check out my new YouTube video. I want to come by and chat with her. And I use the restroom, and I get injured. Well, in that case, if I'm just a social guest, the only thing that Perry has to do is correct known dangers. She has to correct known dangers. So you see, this is a higher duty. If I'm on somebody's property as an invitee, I'm there for a business purpose, then, in fact, I'm owed a higher duty. Interesting case that is in some textbooks. There is a meeting that's being called for a union meeting, and it's at somebody's house. And they're going to have this meeting not only to discuss membership dues, but they also routinely play poker. So one of the members is coming just to play poker, and he gets injured, and the defendant argues that, I'm sorry, you're simply a licensee. You have the right to be there to play cards, and I only had to inspect for known dangers. But if you were there to deal with your dues, right, then you're not just there to play poker, you're there for a business reason, and then I owed you a higher duty of care. So it's interesting, depending on why you're on somebody's property, can indicate whether or not the defendant landlord owes a heightened duty of care, that is to inspect for unknown dangers. That means to do an actual inspection of the property to look for latent problems to protect you against those harms. Does everybody understand the distinction between a licensee and an invitee? Will I test you on it? Probably not. Perry.
What about, because like at my work, as soon as I mop the floors, I have to put the wet sign out. Do you have liability still if someone says?
You could. I mean, what if you have somebody who can't see? Or another case we have is somebody sued Safeway or Lucky's for having a sign like that, and they didn't understand English. And so from then on, they said we need to have these signs in Spanish too. And believe it or not, now it says, I think it's mojado or something, I don't know, whatever, or peligroso for danger, if there's a wet floor. So they have to have both the English and the Spanish now. So it depends on the situation. Most of the time that's going to be pretty good protection. It's not going to be absolute. Because as we remember from the first night of class, the correct answer is always it depends on a certain case of facts. So, any other questions about duty, breach, causation, damages? All right. I'm going to talk about defenses now, and then we're going to take a break and we're going to do an exercise. And defenses can be fairly complicated, but also pretty intuitive. So one defense I already told you about, which is that intervening superseding factor. That can cut off the defendant's liability. The other defense on a procedural basis could be that the plaintiff didn't file their papers on time. They either didn't file the claim form on time if they're suing a governmental entity, or they didn't file their case in court and the statute of limitations is run. Because in California, you usually have 2 years to file a case if you're claiming negligence. Usually 2 years. Okay? It used to be 1 year, now it's 2 years. So if you don't file your case on time, that's a pretty good defense. That's a procedural defense. Then there's another defense called assumption of the risk, which we talked about last week in intentional torts. Assumption of the risk means the plaintiff put himself or herself in harm's way. If I go to Malibu Grand Prix, do they still have those around? Those little race cars? There used to be one in Redwood City where you can rent a car and go around the track, pretend you're Al Unser or something. And if I take out one of these cars and I'm driving rapidly and I'm not driving cautiously and that car turns around, I may have assumed the risk of my own injury. But do I assume the risk of my tire exploding because of defective tire? Or the transmission exploding? Probably not. If I'm sitting behind the baseball diamond at a baseball game and I get hit by a foul ball, maybe I assume that risk. But if I get into an argument with a catcher, I probably don't assume the risk of him coming up and beating the hell out of me with a baseball bat. I probably didn't assume that risk. So one defense is assumption of the risk. The other thing is something that we used to have in California and in some jurisdictions, which is called contributory negligence. This defense of contributory negligence says that if the plaintiff was even 1% at fault for their injury, even 1%, they get nothing. Right? So if I get into a car wreck and I'm not wearing a seatbelt, I may be, in fact, have caused my own injury. And I may have assumed the risk of my own injury because I didn't mitigate. I didn't do what I should have done. I failed to mitigate my damages. If I would have worn a seatbelt, I probably would have had less medical bills. I would have had a smaller wage loss bill. If I would have done something to protect against my own harm, then my case would have been worth less.
Can that include the damage to the car as well?
Sure. Damages of your car you're probably going to get under your insurance coverage. So there's something called property damage and bodily injury. If you're breaking it down, even if you lose property in your car because somebody rear-ended you, if you had a stereo back there or a computer and that got injured, then the defendant may be responsible for replacing that property damage.
Yeah, but if you weren't wearing your seatbelt.
If you weren't wearing your seatbelt, it could go to the property damage as well. That's usually more of a policy issue, so that even if the other side is not held to be at fault, then your own coverage probably covers that. Right? So if you have deductibles or collision damage coverage on your insurance policy, you'll still probably be able to get that, even if you find out that the other party wasn't at fault. Or was at fault, I'm sorry. Now you can see this is a pretty strict rule. It says that if the plaintiff was even 1% responsible for the injury, if they snuck out into the intersection in a car accident case, right, even 1%, if they cause their injury, then they get nothing. That's pretty abysmal for most plaintiffs, right? Basically vitiates any type of claim they can have. Now, we have something called comparative negligence. We don't have contributory negligence in California anymore. The legislators did away with it. You may need to know this on a test, the difference between contributory negligence and comparative negligence, but you also need to know that we don't have contributory negligence anymore. We don't have it. We have comparative negligence. So, let's change the situation. Let's say now that the plaintiff was 23% responsible for her own injury. 23%. So, I'm not great at math, but what is that, a 67% differential? Or 77%? So the defendant is 67% or 77% liable? I think 77. Right? So then, if the case is worth $100,000, now the defendant only owes me 73 or 77K. Right? I'm not going to get full compensation because it was determined through an accident reconstructionist that I was 23% responsible for my own injury. Had I worn my seatbelt and protected against my own damages, I would have gotten 100%. But here, because I was 23% responsible, I'll still get something. Now, it seems like a better plan for plaintiffs. Of course, insurance companies and defendants don't like this very much because a plaintiff can prove some percentage of fault, they're going to get some kind of compensation. Okay? Now, there's one other defense I want to talk about. It's called the attractive nuisance. And it's usually pled as a defense by a plaintiff. This usually happens when kids are walking around and playing on a construction site, right? And the defendant's going to say, hey, look, they shouldn't have been there because we had ropes everywhere and it said danger. But we know kids like to play, and kids might not even be able to read. So if the defendants raise this attractive nuisance as a defense, it's usually going to go against them because the minor's parents are going to say, look, they didn't have enough maturity or they weren't old enough to appreciate the harm, and you should have protected them against that harm, right? Under the law, we want to protect minors. There's a public policy issue that's an edict that says we always want to do what's in the best interest of a minor. Okay? So those are your principal defenses. We're going to talk about different kinds of defenses next week when we talk about crimes. And those type of defenses are like self-defense or defense of others, those kinds of things. But for tort law today, that's our basic elemental breakdown and our defenses for tort law. Any questions so far? All right, we're going to take a break, but before we do that, we're going to have a little bit of a challenge. And this time I'm going to break you up into table by table. So one of your fellow students indicated that 2 tables may be too much to handle because nobody gets a chance to talk. So taking that to heart, I agree that we'll break up in tables. And what time is it now? It's about 5 to 4. Oh my goodness, I've been talking for an hour almost. It's about 5 to 4. We will come back at 4:30. Now, within that prescribed time period, you can take a bio break, use the restroom, get a drink. And I also want you to argue about the case of Paulsgraf versus Long Island Railroad. Now, principally, what I want you to do is try to persuade your classmates that Justice Andrews was correct and Justice Cardozo was wrong, or vice versa. I don't care which idea that you come up with, but I want you to take a stance, and I don't want you to be too malleable. I want you to stay firm in your position and try to convince your classmates that the judge that you tend to side with has the correct analysis. Before we do that, would anybody in the class like me to go over the facts of the Paulsgraf case again? I bet everybody did. I bet nobody read the case, am I right? Anybody read the case? A couple people read the case, all right. So, what happened in Paulsgraf versus Long Island Railroad is a very complicated set of facts. Has anybody heard of Professor Rube Goldberg, who used to teach at UC Berkeley? Okay, so he's pretty amazing. You used to be able to buy these Rube Goldberg puzzles, Eric. I don't know if you can still get them anymore. but it was basically some kind of strange contraption. So you could start something in motion, and then it's going to hit a lever, then it's going to hit a deck of cards, which will propel a bucket to turn over. The water comes out, that hits something else, and some other thing comes about. Well, this is something like that. This is an actual case which reminds me of a Rube Goldberg puzzle. And this is the way it looks. So you have Mrs. Palsgraf standing near the railway platform, and you have a scale. Okay? Clock tower, a scale or something. And that's about 50 feet away from where Ms. Palsgraf's standing. Ms. Palsgraf should eat. She doesn't look too healthy. That's because she's about to get hit by a scale. What happens is there's a train car that's coming towards the platform, and the person who works for the train, like the valet, ingeniously decides to help somebody get on board this fast-moving train. Now, these two individuals are trying to get on the train, and one of them is holding an explosive. By virtue of this valet trying to help these two parties, one of which has some explosive on their body, onto the train, somehow this explosion causes this scale to become loose on the top of this tower and land on Mrs. Palsgraf. Somewhat akin to a Rube Goldberg puzzle, because there's a lot of different moving parts here, and there's a lot of potential liability. So now that you have the negligence formula, duty, breach, causation, damages, defenses, you probably don't have too many defenses for Ms. Palsgraf here. She wasn't really doing anything wrong except just standing there, unless she knew this was going to happen, which she probably didn't. And what about the liability for this guy here who's bringing these people on the train? Did he have any duty to inspect their packages? All right, so those are the basic facts. Everybody clear on that? Now, from that starting off point, the next level of analysis is what the judges of the New York Supreme Court, how they decide to handle this case, because it's pretty strange. So you have one justice, Justice Andrews. He says one thing, and Justice Cardozo says something else. Now, if I tell you what each judge said, it will diffuse the fun of your assignment, and you should have been able to glean that either from the internet or your course book. Would it be fair of me to assign you this project, knowing that that information is available to you either in a textbook or the internet? Or do you want me to give away the entire assignment so it won't really be too much fun?
Don't give it away.
Don't give it away. Scott, right? All right, Scott. So we'll be back about 4:30. And please get a drink of water, use the restroom. Come back. I'd like you to assign one group captain for each group. And a group is one table, so you're one group, etc. One group captain. And they'll come back and tell me why Justice Andrews was correct or why Justice Cardozo was correct. So after we hear from each group, that'll probably take us to the end of class, at which time I want to talk a little bit about strict liability before we go. Okay? Have fun, guys. So wonderful. Many of you, I think almost the majority of the class, has sided with Justice Cardozo. Justice Cardozo, Benjamin Cardozo, was a New York State Supreme Court Justice, and actually in New York there's a law school named after him. Unfortunately, I take a different viewpoint, and I'm glad you guys weren't on my jury, because I side with Justice Andrews. I side with Justice Andrews because Justice Cardozo seems to suggest that there's a zone of danger. So my question to you, and you don't have to answer this, but rhetorically, where does this zone begin and end? I mean, if Mrs. Cardozo would have been standing directly under the scale, would she be within the zone of danger? If she's down even further, could she still be within the zone of danger? Isn't it the better tack to ask, was Miss Palsgraf a foreseeable plaintiff? Because the incident took place, right? As crazy as the whole scheme came down, yeah, true, this valet or conductor on the train had no knowledge of the contents of packages, but isn't it foreseeable that anybody could be carrying anything at any given time? Now, I'm not looking for you to be persuaded by my argument, but just to suggest to you, try to take a look a little bit deeper about this concept of a zone of danger, and you see where it breaks down logically. I mean, if you're to adopt Justice Cardozo's opinion that only people within a zone of danger are entitled to compensation, then how do you determine what that zone is? Do you do it by feet, by yards, by space? Or do you do it by foreseeability, like Justice Andrews suggests? Something to think about. So, thank you everybody for engaging in the exercise. Thank you also for the team captains. I know it's not easy to get up in front of your peers and speak. But remember, this is a very safe place. And we're not done yet. We have to talk about strict liability. So I appreciate the enthusiasm of wanting to get to your next assignment. But I just want to spend a few moments talking about strict liability, because you will be tested on it. Now, strict liability is also known as liability without fault. So no matter how careful you are, you could still be strictly liable. If a defendant argues that they were using utmost care when they were transferring dynamite from one place to another, it's irrelevant. That is not a viable defense to say you were careful, because we have imposed the concept of strict liability to protect plaintiffs against defendants that are engaged in what we call ultra-hazardous activity. So what does that really mean? Well, it means that if we have a concept of liability without fault, we no longer have to prove duty and breach, but we still have to prove causation and damages. So does that make it easier for a plaintiff? Absolutely. It makes it much easier for the plaintiff, because now when they file their complaint in court, they don't have to allege there was a duty, and they don't have to allege there was a breach. So two things off the list. They do still have to prove causation, whether it's proximate cause, using the but-for test, direct causation, or indirect causation. So let's just take it a little bit further. That's sort of our bird's eye view. What is an ultra-hazardous activity? Again, I'm talking about somebody transporting dynamite or explosives. That would be an ultra-hazardous activity. Product liability, so we'll talk about in a moment, but food. If you go to a restaurant and you unfortunately come down with food poisoning through no fault of your own, you eat something, you go to the hospital, and the doctor gives you a diagnosis of food poisoning, then they are strictly liable, because there's nothing you can do as a consumer, right? Once you sit down at the table, unless you're going back in the kitchen and examining the food, which I've never done, the proprietor or the preparer of the food is in a much better position to make sure that food is safe than we are as consumers. So that's why strict liability attaches to food. Medication. We have no ability to examine our medication. Even if we did, I wouldn't know what to look for in examining medication. And explosive we talked about. So for food, medicine, explosives, those are all concerned with ultra-hazardous activities, and the plaintiff can't do anything to protect themselves. They have to rely on the manufacturer or the provider of those goods to make sure those products are safe. Now, one more thing before we go. There's one other type of strict liability, and that's something called strict product liability. Strict product liability. And as a matter of fact, in a strict product liability case, you still don't have to prove duty or breach. You have to still prove causation and damages. Also, there is an opportunity to prove punitive damages. And when you're looking at a product liability case, don't forget that the manufacturer of these goods could also be negligent, right? There's a potential for negligence if you can find duty, breach, causation, and damages, and strict liability. These may not be mutually exclusive, although conceptually they're in conflict, because negligence is injury without fault, with fault, but it's not intentional, and strict liability is liability without fault. So product liability comes in two ways: design defect. That means that that product left the factory in a defective means. And again, that harkens back to that concept of the Ford Pinto case or to the Firestone tire case, when people were driving down the streets in their Ford SUVs and they just overturned because the tires exploded on impact. Then failure to warn. Failure to warn, or inadequate warning, means that I'm delivering this water to you and I don't tell you there's mercury in this water that can cause severe side effects. So what if I don't speak English and I only speak Spanish and there's no Spanish warning on here? You might be able to sue for inadequate warning. If there's no warning at all, then there could be a failure to warn. Now, one more thing I want to talk about, and that is unforeseeable use of the product. If you take the product and you change it in some way after it leaves the factory and it injures you, then you have tampered with that product. Now, one example is a lawnmower. Now, if you are operating a lawnmower, does it have to say on the face of the lawnmower, do not stick your hands in the blades? It's kind of obvious, right? But what if the safety catch on the lawn motor isn't working properly and you're able somehow to put your hand in there? Then that may be a failure to warn. Maybe, because the mechanism wasn't working properly. An unforeseeable use of the product would be using my lawnmower as a bronking bull. I'm trying to get ready for the rodeo and I turn on my lawnmower and that wasn't the intended use of the product. So now I've assumed the risk of using that product in a very strange way, and now the manufacturer may not be on the hook for defective design or failure to warn because I use that product in such a strange, unforeseeable manner, right? I'm using my laptop to give people haircuts. That wasn't the intended use of the laptop. Yeah. Does everybody understand that concept? So if I'm not using the product for its intended use, I can't sue for defective design. Michael.
So, if you have a product that requires to replace like a part within it, and you end up using a third-party product that like ends up like hurting the computer somehow,
then you've tampered with the product. Now, many merchandisers or manufacturers will say use our product only. That could just simply be to get market share and to sell more product. But if you could get injured through using another product and you still do it, you may have assumed the risk. The other question, let's go a little bit deeper, is it foreseeable that somebody's going to be using a third-party product and get injured? And if so, we may still have a duty to warn against that. Does that make sense?
Yeah.
Yes. Tell me your name.
Sarah.
Sarah.
As far as the food, I know sometimes if you go to like a steakhouse, when the server brings out your steak, sometimes they'll ask you to like cut it open and see like if it's what's on it, Is that their way of trying to keep people so they're not liable if
Yeah, so the question was, is one of the ways of minimizing liability from a restaurant to actually cut your meat in front of you to show you that it was either cooked well enough or how you wanted it. Now, there are some safety mechanisms in place at restaurants for cooking, particularly chicken, because you can get salmonella poison from that. And they must, I've actually asked, next time you make that chicken dish for me, it was a little bit dry. Could you not cook it so much? And they say, sorry, Mr. Silverman, we have to cook it to that degree. Otherwise, we could be liable for undercooking the food and you can sue us for salmonella. So that could be one potential way of them guarding against liability, but they also have very specific safety protocols for cooking certain meats at a certain level of heat.
So, say you cut it open and it looks fine at first, but then
Yeah, so if you can prove that they caused injury to you, if it was the steak that you ate that caused your symptoms, then that's strict liability. So they're responsible for it. One very strange case I had somebody who came to my office and they claimed that they went to a seafood restaurant and the seafood soup that they ate was poisonous, that they got food poison. And it was so incredibly poisonous that it made them vomit so much that their retina became detached. And so, well, that seems kind of far-fetched. So back to the Cardozo-Andrews correlation, from Andrews' perspective, well, maybe it's foreseeable for somebody to lose their retina if they eat bad food, but Cardozo would say that's ridiculous. You can't lose a retina from eating bad soup. I don't know. Maybe you're still within the zone of danger. But with food, it attaches what we call strict liability, because the consumer has no opportunity to examine the food or protect themselves. All right? Any other questions? We'll see you next week. We'll talk about crime.